Hi everyone, I'm attorney Vincent Hein with Russell Law Offices, and in this video we'll talk about powers of attorney for healthcare, powers of attorney for property and finance, as well as a living will. So first off, why do powers of attorney? Well, a lot of the reason behind doing powers of attorney is really to keep you out of guardianship court later on. So a lot of people think by virtue of their marriage, their spouse can simply sign on their behalf. So, for example, you got sick, you had a stroke, now your spouse wants to sell the home, they cannot sign your name on your behalf. They have to get the authority to sign from somewhere. And so they would get that from your financial power of attorney, but if you didn't have that, they would have to petition a court for guardianship. Well, that's going to be a much more expensive process, much more intrusive, and then once a year, your guardian will have to provide an accounting to the court to show what happened inside the guardianship account, the guardianship estate. And really, it's kind of a safety mechanism so that the court knows the guardian is not stealing from you. Well, if you simply have a power of attorney for finance, you should be able to avoid all of that. Now, the same is true for your power of attorney for health care. We want somebody to be able to make your health care decisions for you, and you do that by simply naming an agent in your health care power of attorney. And so if you're married, typically it's your spouse, and then after the spouse, it's a child, a family friend, whoever it might be. And this would have the right to, quote unquote, pull the plug. Now, the healthcare power of attorney always has a trigger, or I should say almost always has a trigger, meaning that generally two doctors or one doctor and one psychologist have to examine you personally and say in writing that you lack capacity. Then your decision-making shifts to the person you named on the document. Your financial power of attorney can also be designed that way, or frequently there's no trigger at all. Some people call it springing, I call it a trigger. But the financial power of attorney can also kind of split the difference in some way, saying if it's my spouse, then there is no trigger, they can use it right away. But for any non-spouse, I have to be incapacitated before they can use my power of attorney for finance. And depending on if we want to do Medicaid planning down the road, we may want some more aggressive provisions in your financial power of attorney, the right to gift, including the right to gift to themselves, right? The right to self-deal, and the right to enter into various marital property agreements, and basically the right to do spend downs and deplete your assets. So that's an important discussion to have. It's not appropriate for everybody, but you do want to have that language in there if that is a consideration, because otherwise your agent doesn't have the authority to do so, and that can slow down the Medicaid crisis planning if we're doing that. Now, the other thing that people are familiar with is the living will. The living will is really called a declaration to physicians, and ultimately it's inferior to the healthcare power of attorney. Well, why? The healthcare power of attorney names an agent. It names a person who's going to make decisions for you. The living will doesn't name anybody to make decisions. It does have some check the boxes that talk about whether you would want life support and things like that. So it's not without value, but my opinion with the living will is it's best for somebody who cannot name an agent. Sometimes it is done in conjunction with the healthcare power of attorney, but most of the time the healthcare power of attorney would just take care of what's in the living will and at the same time appoint that agent to make decisions for you, including the pull the plug provisions. So that's the way the healthcare power of attorney works. And the reason you do these is to avoid guardianship. So I tend to explain these as really it's kind of like guardianship insurance. If you have these documents in place, nobody should have to be appointed guardian later. There's always some exceptions, like if a protective placement is needed or something along those lines. But generally the point of these documents is to keep you out of guardianship court. That's going to be more expensive, more intrusive, and simply more time consuming for your family members that are involved in doing that. So that's the point of powers of attorney. There is a bill currently that might make some alterations to that, so we'll have to keep our eye on that. But right now, nothing is impacting what I've already just said. So we'll have to keep our eye on that, but do your powers of attorney. It doesn't matter if you're doing a will or a trust. You should have these in place to make sure you don't have to have a guardian appointed later on. It's simply not worth it. It's much cheaper, much more advantageous to you to simply have some powers of attorney in place. And just like there's a guardianship over your person and a guardianship over your estate, right? There's powers of attorney over your body, that's your health care, and there's powers of attorney over your stuff, that's your financial or property power of attorney. So get those in place. They're very cost effective, and I hope you learned a little bit in this video. I'm attorney Vince Hein with Russell Law Offices. Thank you very much.